If it's not in the indictment, I'm uncomfortable telling them a time.
I'm sorry?
If it's not in the indictment, I'm uncomfortable telling them a time.
Understood.
All right.
I agree with the court on principle. I just don't have the indictment memorized, so I don't remember. If we can pull that up.
There's no time? I don't expect that there's any time. to be
All right.
found.
So I'll say you have the evidence, and remember, you are the fact finders, or something to that effect. All right. Are the video clips of Karen's interviews evidence? How can we consider them? So
Hello,
I'll tell you what I
mister.
was planning on saying, then you can add to it.
Sure.
Yes, the videos are evidence. Give them whatever weight you think is appropriate to give them. And then I would give the digital evidence instruction and the humane practice instruction.
The only thing I would respectfully ask the court to include in that sentence is give them whatever weight, if any, you deem appropriate.
All right.
If any.
Okay.
Thank you. Otherwise, it's fine.
Raise the issue of what? You ready? Hot mic, hot mic. I'm gonna have to go back and listen to that. Oh, ha! Wrong one.
Okay. What's the Commonwealth's position?
Got two screens running.
We have a different perspective on
Appropriate to give them,
Yep.
and then I would.
Any you deem appropriate.
All right.
If any.
Okay.
Thank you.
What does he say?
Otherwise, it's fine.
This bit. Raise the issue of preserving the record. Oh, got an itch that I can't reach.
Okay. What's the Commonwealth's position?
We have a different perspective on that.
Okay.
The first part of the question, are the video clips of Karen's interviews evidence? The answer should be yes.
Okay.
How can we consider them? I think it's fair to say you should weigh the defendant's statements as you would evidence. Since they've been introduced substantively, they are like any other piece of evidence. There's no difference, and there shouldn't be any reflection of a difference in the answer. We didn't introduce any evidence in this case and say you should give it any weight, if any at all. We didn't provide a limiting instruction in any way, and these shouldn't be so limited. This is just like a photograph. It's no different than a physical piece of evidence. And so I think the answer should simply be yes. You should weigh the defendant's statements as you would any other piece of evidence. I do not think the court should give humane practice or digital evidence. It suggests that there's some deterioration or further analysis that
Hey, baby.
those instructions.
You go and get
are
mummy a
given during
t-shirt.
the
She's hot.
charge. In addition, those instructions are in the hand of the written jury instructions. And so, to put it most simply, as I think that we should, is this is a piece of evidence, and you weigh it like you would any other piece of evidence, whatever they decide, rather than give them guidance to curtail it or to limit it in any fashion.
My only suggestion, Your Honor, is that every single piece of evidence that's provided to them, it's in keeping with Massachusetts laws and keeping with the responsibility that they have. Every single evidence is given the weight, if any, they deem appropriate. That is not a
I have to go and put a
misapplication
t-shirt
of
on.
law. I think the Commonwealth's suggestion suggests in the answer that they should or they have to give those statements weight, and the law is they don't have to give them any weight. So I think the appropriate comment by the court is exactly as the court suggested initially, which is you give it whatever weight, if any, you deem appropriate.
She's trying to figure out how she can give the Commonwealth more, in my opinion.
That human factors instruction basically says if there's an admission, you have to find that it is voluntary and intelligently made. In other words, she's making these statements on these interviews voluntarily. So she's going to give that instruction. That I don't think is an issue.
I'm telling you though, Michael, she's trying to find how she can give Brennan more, right? Because he wants more. He wants basically,
Yeah, he
legal
wants to put a
concessions.
time on it. I'm surprised she immediately poo-pooed that. In terms of the video evidence, I don't know what she can do other than say it's in evidence and give the human factors.
Yeah, it's an evidence and give it the
Charge.
weight, if any, right?
Yeah,
He
if any,
suggests,
you know,
if any, right?
if
Then,
any, that's yeah,
that's
because
what the-
you don't want to say give it the weight it deserves. That leads them.
but she's like, that's what she's looking. She's looking to see what else she
You
can
sure
do.
she's not working on the third one?
No, because he objected to the he objected to the weight, and so she's
I don't-
now,
I don't know where she can go that helps them.
well,
it-
she's trying, in my opinion. But I think the telling question is, if we convict her of that, do we can we does that mean she gets convicted of
course.
everything above it? That's telling, because
course.
they don't want that to happen.
No, and that would also be, I think, a contradictory verdict form slip. I don't think it would be upheld on appeal. It doesn't make sense.
All right, so what I'm going to say is, yes, the videos are evidence. You should weigh the defendant's statements as you would any other piece of evidence and give them whatever weight you deem appropriate. But first,
She
and
left
I'll
out
go
if
and I'll
any.
read the
Left the
electronic
any, yeah.
communications and the humane practice. That covers it.
If the, I don't have a principled objection to it if the court adds the word if any,
I understand.
because every single,
She's
I
not
don't
gonna
want
do
them
it.
to think, for
Talk it out.
instance, the way that it's worded as the Commonwealth suggested it, they have to weigh it the same way they weigh other pieces of evidence. Every single piece of evidence is weighed in and of itself. It's individual to the piece of evidence that's presented. For instance, they could weigh the statements by Ms. Reed. They could give it no weight. Each individual juror could decide, I'm going to dispatch it altogether and give it no weight, while giving another piece of evidence, like whatever that might be, the testimony of one of the ARCA witnesses, complete weight. I think that we need to stress that the clips bear no additional weight, no additional gravity than anything else that they've considered. And the only way to do that is very simply, you give this the weight, if any, that you decide is appropriate. It doesn't, I think, comparing it and contrasting to other pieces of evidence in the case, it's unnecessary, and it tends to suggest they have to give it weight.
Okay. So your objection's noted. Now let's get to the.
Thanks
After
anyway.
she said she
third
was going to
one.
give it, she changed her mind. Okay, because there's nothing else she can do for the Commonwealth, so she took that
Does
out.
convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge? What do you want to say, Mr. Jackson?
No.
Your Honor, I appreciate the effort that the court went to amend the verdict slip as it relates to count 2. And I think there are some excellent suggestions by the court in the verdict slip. By and large, I think question number 3 is answered by the amendments in the verdict slip. So we certainly could say something like, does convicting guilty, the question was, quote, does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge? The answer is no, obviously. And perhaps we could formulate an answer that says something along the lines of, no, new verdict slips have been provided that will make it more clear, or something of that nature. As well as a decision of guilty on the OUI charge 002, number 5, is an explicit acquittal on the higher charges in offense 002. which is a proper statement of the law.
Sorry, what have I missed? You know when you have a bloody, it's not a hot flush, it's power surge, and then I got an itch right in the middle of my back, and how frustrating it is to not have arms that will absolutely fucking reach it. I would pay $100 for this. My back scratcher. Oh, it was great. So what decision did she come up with? Is she going to change the verdict slip at all, or fill me in? I was a scratching. God, it was good too. If I could remember what sex was like, it was probably better. All right.
And then there are suggestions that we have
Count 2, lesson number 5. What does that mean?
regarding the edits that the court has made to the verdict slip. And
Wow,
I'm
there's
happy to go over
edits.
those with you and put those
Okay,
on
go
the
ahead.
record.
Yeah, but what about it?
We need the edited slip. There's been edits.
With regard to going from the top to the bottom, just under number 1, number 1 reads, not guilty of the offense charged or any lesser included offense. We would propose that the court add the language, the consistent language that it's added throughout the verdict slip. If you quote, if you find the defendant not guilty of the offense charged or any lesser included offense, comma, stop and sign the verdict slip, period. That's the only place that that language doesn't appear, and I think it should appear.
Okay.
The second is a relatively minor issue. However, under number 2, sub 2, the parenthetical check one or both of the following, I think it should say, just to clarify it further, if guilty, comma, check one or both of the following.
All right. I think I'm going to leave it because it appears only under the guilty.
It appears only on,
Under the guilty. So go ahead. I'll hear you further.
going further,
No waste your breath,
going under
Jackson.
number 3, toward the bottom of the page, in the parenthetical that the court suggested, which we find is excellent. If you find the defendant guilty of the lesser offense
Okay.
of involuntary manslaughter, we would simply add that clause.
So we'd have to add it in all of them,
Correct.
which makes sense. I think
Correct.
we had it in the first one.
Right.
Okay.
And then moving to page 2, at the top of the page under sub 4, again,
Hold on one second.
of course.
Okay.
We had the same suggestion. It appears that the court is not inclined to give it. If guilty, check one or both of the following. And there's a typo. It says the
We
parenthetical says
fixed it.
check one of. Okay.
Yes. So we changed of to or.
So my only suggestion to that would be to, again, add the if guilty, comma, check one or both of the following.
Okay.
On that page, going down to the bolded parenthetical, same thing. If you find the defendant guilty of the lesser offense of motor vehicle homicide.
Okay.
Moving down under sub 5,
We
the
still
OUI.
need to say stop and sign the verdict slip.
Right, after the word stop and sign the verdict slip.
Yep.
And then under sub 5, again, the same thing. We just suggested that for consistency that it say, if guilty, check one of the following of the both. And the final edit would be in the final parenthetical, the last sentence. If you find, I think her should be
Yeah.
changed to the defendant. If you find the defendant not guilty on this offense and all other offenses, check the first box on page 1.
Okay.
And
Oh,
those are the edits that we have suggested for the verdict
All
slip.
right.
why didn't she do that? at
Mr.
the
Brennan?
start?
I don't have any disagreement with the edits.
Because the jury have actually asked for it to be changed. If they're showing confusion. That's why she's got to do it now.
Nuance of selecting one guilty or not guilty. I don't think it needs to be explained. I think that the edits, this proposed instruction explained it.
All right. What
I
I,
don't have any issue with if you
Oh, thank you.
state,
The hot cup of soup, I think, just tipped it off. I was dripping.
decide on a lesser included offense does not
It's settling now. Now I've got goosebumps.
earlier offense. I'm not sure of the exact language that can be. I don't think that's necessary.
Oh, there's a sigh.
Something I wouldn't have an objection to, but I think the form that you filled it out with the credit is going to be sufficient for them to follow.
what do you think about the defendant's position that, if you were to find her guilty of operating under the influence, Mr. Jackson said explicit acquittal. I don't like that language. I think if you find it, it means you have
Well, she
found her
don't.
not guilty of each of the others.
That would be fine with us.
I think it's better if you find her guilty of any lesser included offense, it would not include the higher offense.
All right.
I think that's just confusing.
So what I planned on doing was bringing them out and giving them each a copy of the amended verdict slip, explaining that it really is consistent with the jury instructions I gave them, but walking them through it. So we start from the top and then explain, if you find the defendant guilty, you're done. Stop, sign the verdict slip, and let the court officer know you have a verdict or something.
I prefer that.
Yeah, I think I'll walk them through it like we do in civil cases.
I don't have any objection to that. The only other thing is the digital instruction.
Yes.
We don't believe that it's necessary. I don't think that we should reemphasize that, and we're not asking for it. That
All
would
right,
be-
so you're waiving it?
We're waiving it.
Okay,
Yes,
all
thank
right.
you.
I will do humane instruction, humane practice instruction. So I need 5 minutes, and Tori, your computer, to amend this if we can, and we'll make copies. So we'll bring the jurors in. Let them know that we'll be bringing them in shortly, Tony. All right, thank you. All. All right, jurors, we're in receipt of your question. We've been working on making sure that the answers we give you are the right ones, so it's taken us a while. So the first question, what is the time frame for the charge? Offense 002, Section 5, OUI at 12:45 or OUI at 5 a.m.? The answer to that question is that you folks have all the evidence. And remember, it's only you who decide the facts in this case. All right, that's the answer to that question. You are the fact finders. The second question, are video clips of Karen's interviews evidence? How can we consider them? Yes, the videos are evidence. You should weigh the defendant's statements in the videos as you would any other piece of evidence and give them whatever weight you deem appropriate. But first, before you may consider any such statement, you're going to have to make a preliminary determination whether it can be considered as evidence. You may not consider any such statement in your deliberations for the truth of any such statement unless, from all the evidence in the case, the Commonwealth has proven beyond a reasonable doubt that the made the statement that she's alleged to have made and that she made it voluntarily, freely, and rationally. So that's the answer to that question. So for the third question, does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge? So with that, what I'm going to do is I have amended the verdict slip. It's the exact same verdict slip, and it's still consistent with the jury instructions I gave you, but it's a little bit easier for you to follow. And for purposes of going through this, we'll go through it together, and I've got a copy for each one of you, okay? All right, so you'll see it really is the same verdict slip, but we've added a little bit of language to help you follow it through. So the first charge, manslaughter while operating a motor vehicle under the influence of liquor. So first, in the above entitled case, we say the defendant is, 1, not guilty of the offense charged or any lesser included offense. If you find the defendant not guilty of the offense charged or any lesser included offense, stop and sign the verdict slip. Now, then you go on to guilty of the offense of as charged, manslaughter while operating a motor vehicle under the influence of liquor. Check one or both of the following: manslaughter while operating a motor vehicle under the influence of liquor, and or manslaughter while operating a motor vehicle with the blood alcohol level of 0.08 or greater. If you find the defendant guilty of manslaughter while operating a motor vehicle under the influence of liquor, stop and sign the verdict slip. That means on each one, when you stop and sign the verdict slip, that means you have a verdict on this indictment. So stop and sign the verdict slip. If you find her not guilty of manslaughter while operating a motor vehicle under the influence of liquor, then continue below to the lesser included offense. And first, under 3 is involuntary manslaughter. If you find the defendant guilty of the lesser included offense of involuntary manslaughter, stop and sign the verdict slip. If you find her not guilty of involuntary manslaughter, then continue to the next page. Guilty of the lesser included offense of motor vehicle homicide, felony OUI liquor, and negligence. And you have to check one or both of the following: motor vehicle homicide under the influence of liquor, and or motor vehicle homicide by operating a motor vehicle with a blood alcohol level of 0.08 or greater. If you find the defendant guilty of the lesser included offense of motor vehicle homicide, felony OUI liquor, and negligence, stop and sign the verdict slip. If you find her not guilty of motor vehicle homicide under the influence of liquor, then continue below to the guilty of the lesser included offense operating under the influence. And you check one or both of the following: operating a motor vehicle under the influence of liquor, and or operating a motor vehicle with a blood alcohol level of 0.08 or greater. If you find the defendant guilty of operating a motor vehicle under the influence of liquor, then stop. If you find the defendant guilty, you stop and you sign the verdict slip. If you find the defendant not guilty on this offense and all other offenses, check the first box on page 1. And remember, your decision must be unanimous. All right, does that make it any clearer, hopefully? All right, so with that, I am going to send you back out.
Before the jurors are set,
Sure, why don't you come on over?
Well, while they got a sidebar on this, wow, gee, it sounds awfully like the one that Nettie asked for yesterday.
Almost.
think?
Almost, except that she has to keep talking guilty, right? Guilty.
Yes. It does give them a roadmap, which they did not have before.
Uh-huh.
The if then.
I should have been
right?
part of the jury instructions
Which
as
is
well.
one thing that it should have had. The proposed suggestion was clearer. It just had a column: guilty, not guilty, guilty, not guilty. Each successive lesser included. This is not that clear, but it's far clearer than it was, and it's just a joke that we had to get to this point to make that happen.
Right. And she
myself
had it
say this, and I'm glad counsel told me I did. So if you go back and look at the form after 4, if you find the defendant guilty of the lesser included offense of motor vehicle homicide, felony OUI liquor, and negligence, stop and sign the verdict slip. If you find her not guilty of motor vehicle homicide under the influence of liquor, then continue below. I think I said, then find, I don't know what I said. I heard myself read the guilty of the lesser included offense.
Right,
So
that's what she
if you
read.
find her not guilty of motor vehicle homicide under the influence of liquor, then you continue to decide whether the Commonwealth has proven to you beyond a reasonable doubt that she's guilty of operating under the influence of liquor. And if they have not, and if you find the defendant not guilty on this offense and all other offenses, then you go back and check the first box. So you follow it from the top to the bottom in this manner. Okay.
To the bottom.
Thank you very much. We're
To
gonna
the
release
bottom.
you.
Follow it from the top to
But what
the
about
bottom.
lunch? And the options are built in the law, not in theory. If they come back with a a verdict on more than one count, but they're hung on a separate count, they are to report those 2 counts, whatever counts they came to a verdict on.
So that's for a later time, right? So this is at this point.
Right.
It's premature, it's hypothetical, it's theoretical. I understand your point. I think I disagree with you at this point. It may be something later, the way the
Unfortunately.
question's worded. If I find this, if we do this, I'll hear from the Commonwealth.
We don't know what the question is, but it's a
We
question.
agree it's consequence related. The first suggestion, I think, is most appropriate, and we would endorse that.
I'm going to do that at this time, Mr.
Mhm.
Jackson. I'm not going to have a back and forth with them. I'm simply going to say, because it's true, it's the law, that this is not a question I can answer.
We don't know what it
I would
is.
strongly suggest that we find some other way. If that question continues to remain, then they're not going to ask that question. I don't think the court can say, or should say, I can't answer the question, because the court can answer that question. The court absolutely can answer it. I would simply say, this question is not before the court without further information, or something like that. Not the court can't answer that question, because if that question remains in their minds, we're going to end up in the exact same position that we were in last year.
There are other steps that can be taken to perhaps.
Oh,
Whatever
you say?
those steps are, I think the first step down the wrong path is to say, throw our hands up and say, well, we can't answer that question. Well, we know we can answer.
So I don't know if I want to put you in an uncomfortable position, Ms. Giannetti. I'm inclined to answer the question the way I stated.
Could we have 2 minutes to confer with counsel, John?
The sound is awful because they're not at their microphone.
Guys are 10 minutes late.
We just need 1 minute. Thank you.
fuck, just rush them, you know. It's not like someone's life's on the fucking line.
Okay, so what's happening is, Michael, you called it right when you said it's a question, because you could tell about the note cards. So apparently it's a theoretical question, and she won't answer it. And I guess Alan Jackson wants her to inquire. The question is the question that we've heard in the past. The jury wants to know what
What is the
about
big
if they
deal?
acquit on 2 of the charges and hang on the 3rd. And the court is refusing to answer that. Apparently, that's what the question is about.
That is over our objection.
I understand.
I just want to make sure the record is absolutely clear. That's over our objection. I don't think that's an appropriate answer to a very, very clear question. It could be answered in an innocuous way that
Yep.
does not affect Ms. Reed's rights.
Yep.
I think
Okay.
This way it does.
Okay, it was a clear question that the defense first told me to ignore. So,
I didn't
Is
say
that-
to ignore it, Your Honor.
all right, we are all set. So let's.
Just fuck off, you fucker. Just
All right,
fuck
let's
you.
listen, Michael. I hope you can
you.
have